I'm not very envious to speak to a group like this during lunch. I figure I have 20 minutes at the max, and I'll try to keep it to that a little bit more. So I'll just start right away. My topic, the vocation of the judge, at first blush might seem rather straightforward, even easy, but I can assure you it is not. I do not intend to address what the judge does in court or describe the judge's work day, except perhaps tangentially. Rather, I want to examine the judicial vocation as a way of life, as an ethos, much like the Navy SEALs or U.S. Marines, whose ethos is the pursuit of military excellence, so also the judge's ethos, his or her vocation, is to pursue judicial excellence. Let's focus first on the word vocation. Now, I use my cell phone. If you don't have the Oxford English Dictionary on your cell phone, put it in there. It's free and it has all the roots that I'm going to talk about. Vocation in its common meaning. The Oxford English Dictionary defines vocation as a person's employment or main occupation, just like before, especially one regarded as worthy and requiring dedication. At a superficial level, that definition's okay, but it's not exhaustive. The word vocation is not necessarily synonymous with occupation or employment. Vocation comes from the Latin vocare, which means to call. That is, a vocation is a calling, a strong urge towards a particular way of life, or a career, or a vocation. For completeness, the word judge derives from the Latin jus, meaning law, and dicere, meaning to say. That is, a judge decides the law or says what the law is. Thus, the vocation of a judge is the way of life, the career, the profession of a public official that decides the law in court. But it seems to me even this definition is incomplete. It describes only what the judge does. It is like saying that the vocation of a general is to lead soldiers in combat or to conduct war, or the vocation of a doctor is to treat patients and perform surgery. It is, of course, but these definitions leave us wondering for what purpose and to what end. Better stated, the vocation of a general is not merely to conduct war, but rather to win battles, to be victorious in war. Likewise, the vocation of the doctor is not merely to treat patients or to perform surgery, but rather to heal, to bring patients back to health. That is the reason a president selects a general in the first place, and why most of us choose a physician. So also with a judge. The essence of a judicial vocation is not merely to decide the law, though that is an important part, but to administer, or rather to do justice. Now, I don't mean by doing justice to be acting outside the rule of law. I do not mean that, but always within the confines of the law. Justice is the talisman of the judicial vocation, not in the sense of magical powers, but in the sense of its original Greek derivation, telos, meaning results or end. We can see this purpose easily in the statutory oath of office for judges of the United States, and that's 28 U.S.C. section 453. That oath prescribes the judge's duties and is more a complete statement of the judicial vocation. Section 453 states in pertinent part, I do solemnly swear or affirm that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as a United States judge under the Constitution and laws of the United States. So help me God. The word justice is mentioned prominently. I do solemnly swear that I will administer justice, though seemingly limited by the language that follows. The oath is comprised of two prongs, one relating to the notion of fairness and the other relating to the duty to respect the law. Pursuant to the fairness prong, all litigants are equal before the law. No litigant is favored over any other litigant, especially with respect to person or wealth. The duty prong requires that the judge to apply considered law. Now, I use just this word to describe that it has to be deliberately and impassionately researched, and there needs to be deliberation. Always in the context of the law that is existing, and apply it impartially to each party. Thus, the judicial duties required by Section 453 aim at a form of justice as their end. Importantly, justice in the sense of Section 453 is not a definition, but a set of duties which the judge must comply in a court of law, whether at trial or at a hearing, or in considering motions and other legal matters in individual cases. That is, in legal proceedings occurring in courtrooms every day throughout the nation. It requires the judge to discharge his or her duty. The judicial way of life, in my view, requires more. It requires the judge to develop certain judicial habits or traits, certain judicial virtues to enhance the quality of the justice provided to the litigants in court. A judge must be industrious, deliberate, courageous. He or she must exhibit self-control, high-mindedness, and a professional respect for the parties and their counsel. The judge must be knowledgeable, and again here we're talking about knowledgeable of the law, and not only the black letter law, but the principles of the law, the deeper logic in the law. In essence, the judge has to be a constant student of law. Fair-minded, truthfulness, impartial, and above all, just. The judge must constantly strive to create a judicial atmosphere in court conducive to justice. Conversely, a judge cannot be bumptious or indolent. He or she should not be shrill or vainglorious, autocratic, arrogant, standoffish, or ignorant of current law. Because justice in this sense is best understood in actions of the judge, then by definition, permit me to give two anecdotal examples. I was confirmed by the Senate on Thursday of Fiesta Week 1988. I'll never forget this. Of course, I was elated. I was sworn in the next day, the day of our annual Battle of Flowers parade, which is a big deal in San Antonio, which I had hoped to enjoy that afternoon. What I didn't know then was that I would not have any time to enjoy the parade or any other fiesta event. In fact, rarely in the next 27 years did I attend any of the fiesta events. Sometimes I did. You just don't have time. You simply don't have time as a federal judge. Immediately after swearing in ceremony, I was assigned 12 matters that were scheduled to be heard that following Monday, 3 days. One was a Section 1983 alleging a violation of an arrestee's constitutional rights in failing to prevent the arrestee's suicide while in custody. If that doesn't make you want to work the weekend, nothing will. I started working immediately. Many of those 12 matters did not take long to consider. I read the motions and the memos of law, researched and reviewed the case law, and reached tentative conclusions. But the 1983 and one other matter were more difficult, and I took all day Saturday and Sunday to prepare those cases. I arrived at court on Monday with tentative conclusions, but also with many questions for the parties. Later in my career on the trial bench, I would enjoy these hearings because I could listen to the attorneys face to face and how they would react to each other, ask pointed questions material to the proper resolution of the case, especially when I thought that there were gaps in their arguments. These questions also serve to challenge my own tentative conclusions. You keep the conclusion in abeyance until you actually can rule. By necessity, I was starting to develop some of these traits: industry, deliberation, attention to factual and legal detail, professional respect for the litigants and their counsel, the ability to listen to all the parties, to concentrate on the issues and not the litigants themselves, and to be attentive to the full scope of the issues before the court. Before ruling, I would explain my reasoning on the record. Why? Because once it's on the record, it is before the Court of Appeal, and you better get it right. It forces the judge to concentrate and to analyze and to do what is right for the parties. Addressing the parties' issues and arguments, always pointing out where I would disagree with them and citing the law in which I relied. If I was not sure of the proper resolution, I would hold the ruling in abeyance until we could conduct further research and produce a detailed written opinion, again with my reasons, authorities, and rulings for possible appeal by the parties. A second example, but from the litigant's perspective, occurred 2 years later. At the end of my career as a trial judge, I would receive an extraordinary compliment. An attorney from Comstock, Texas, a rather weather-beaten old cowboy, came up to the bench after trial and said in his Texas drawl, "Judge, I just want you to know that although we lost, I thought we received a fair trial." I thanked him. He walked away. I never saw him again, but I always remembered the words that he said. I would attribute the compliment to the development of at least some of these traits I've mentioned, but I could also sense by the tone of his voice that he had not always been treated the same way. Unfortunately, some judges aim at either results or simple efficiency to manage their overworked dockets. I do not recall what I may have done or said at trial to earn his respects. Perhaps he thought I had paid close attention to his arguments or objections. Or maybe he was surprised I had ruled for his client on some issue. Or probably he simply sensed that he and his client were treated fairly. No matter why he came to that conclusion, he believed that his client had received what he intrinsically knew as justice. I have purposely shied away from any discussion of justice as sensed by that attorney. Simply put, a discussion of the concept of justice as a theoretical idea is difficult at best, but necessary if we want to have a better understanding of judicial ideal. Any discussion of justice must include Aristotle's analysis in Book 5 of his Nicomachean Ethics. Justice, according to Aristotle, is a virtue that regulates all relationships between individuals within the state, and not primarily matters in court of law. It is the complete or the highest of all virtues in relation to its citizens. For Aristotle, justice is the same as righteousness or honesty. As he points out, a ruler, and I would add a judge in court, is the guardian of what is just, and as such, he is also the guardian of equality and fairness. Justice, according to Aristotle, is the experience in the nous. This is a Greek concept prior to Christianity, usually translated as intelligence. He describes the nous as follows: as the best part in us, whether this is intelligence or something else, which by its very nature rules and guides us and gives us our notions of what is noble and divine, whether it's itself divine or the most divine thing in us. That's all he describes that experience, described by that symbol, that word, nous. Eric Voegelin also discusses the Aristotelian concept of justice in Book 5 in his book called Anamnesis, another Greek word meaning to recall. He wrote it in the 60s and 70s, and it's the same concept that you have in Plato. You recall the past. You recall your origins of our civilization. Like Aristotle, he places his discussion of justice under a more general discussion of what is right by nature. Voegelin writes, what is right by nature is the noetic, the experience in the nous, experience best described as the tension between the divine, immutable essence, if you want, after Christianity, God, and human, existentially conditioned mutability, a human being. And there you have it, juxtaposed these two poles, humanity on one side, or human beings on one side, and this divine essence that's immutable. I heard a discussion, or described best, it's sort of like being in a room, and it's dark, and you have a big heavy rope, and you can never see what's on the other side, but all you can feel is the tension pulling towards whatever is on that side. Voegelin continues, and this is another important quote. What is right by nature is not given as an object about which one could state correct propositions once and for all. Rather, it has its being, its existence in an individual, in man's concrete experience of justice, which is everywhere the same, and yet in its realization, changeable and everywhere different. To understand that is the following. All of us here, every one of us here, thinks they know what the word justice means. But in your application, how you treat people, many of us, most all of us, would treat people just a little bit different. So yes, the immutable idea, the essence, is the same, but in its application, it is different. You have to remember that in Aristotle's philosophy, ethics is part of practical, it's practical science, not theoretical science, not either theological or philosophical, but a practical science. And it's in the action that you have, if you want to call it that, the definition. How you act as a just person. There's thus this existential tension that cannot be resolved theoretically, but only in the practice of the man who experiences it. The attraction towards this ideal to do what is right, to do what is just, is what ultimately drives judges to aim at that immutable essence of justice, within their own human mutability. Some judges constantly strive for that ideal. It becomes a way of life, an ethos, a vocation. They develop good judicial habits and constantly strive to attain the ideal of justice. For others, however, it may be different. A trial court may find it tempting, given his or her abundant discretion, to control the litigants in court, to favor one side or the other, or to rule based on efficiency. Or an appellate judge might find it easier to write an opinion at such a general level of analysis that it could support any result, rather than delving down to the level of specificity that will actually answer the issue before the panel. Or a Supreme Court justice who might enjoy the sense of power in finding constitutional rights outside the written Constitution. Also concerning is that Section 453 assumes that the Constitution and laws of the United States will always be just. What if they're not? What if the law to be applied in a court case is unjust or immoral? Several examples come readily to mind. The laws on slavery, eugenics, legal segregation, abortion, capital punishment. Now, I realize that not everyone in this room would agree that all of these are examples of unjust or immoral laws, but most here would consider one or more of these unjust. Faced with applying unjust law, what is the duty of the judge who aims at justice as an ideal? The quintessential moral response is illustrated in the scene from Robert Bolt's play A Man for All Seasons, when Cardinal Wolsey questions Thomas More how a consular of England can obstruct certain measures for the sake of his private conscience. More responds, "I believe when statesmen forsake their own private conscience for the sake of their private duties, they lead their country by a short route to chaos." I agree. The judge must never lose sight of his or her own conscience and must act accordingly. But must judges, faced with this moral dilemma of applying an unjust law, always resign from office? And my answer is no. I make a distinction between laws that permit immoral or unjust acts from laws that compel immoral or unjust acts. As to the former, the judge has a duty to follow the law, but also to articulate reasons why that law should be overruled. If the judge is confronted with the latter situation, he or she, in my view, must resign and not become complicit in the injustice. Now, my friend told me, said, "You really would do that?" I said, "Yeah." And we have never, not yet anyways, had a situation like in Nazi Germany. There was a program called the T4 program where anybody suffering from mental illness was eliminated. That plan was presented to the judges. They said nothing, absolutely nothing. This is the type of evil that I'm talking about. I was faced with the former situation, raising different issues of the right to abortion, each of which had been factually and legally addressed by the Supreme Court. I followed the law as required by my oath, but concurred specially explaining why such precedent was inimical to the Constitution. In a fourth abortion case where the court had not addressed the specific facts nor the specific legal issue, I dissented from the majority opinion again with a full explanation of my dissent. I was never faced with the latter scenario. One final observation. Many of the examples of unjust or immoral law stem from judge-made law. They involve two similar legal questions. How far are we willing to go to include or exclude an individual from the protections of, quote, person, end of quote, under the 14th Amendment? And secondly, what aspects of human life or activity should be constitutionally protected? It presupposes an understanding of two very basic questions. What is a human being, and what are the essential aspects of human life? A not too dissimilar question was tackled almost 70 years ago by Albert Camus after World War II. He wrote an extraordinary book entitled The Rebel, where he tried to come to grips with the mass atrocities and simply sheer evil, the darkness of Europe at that time, of the totalitarian regimes during the war, and to determine their intellectual underpinnings. In his last chapter, he observed, in almost an aside on two different places, but I'll paraphrase them together, that we need to return to theory that recognizes limits. Return to theory that recognizes limits. But at the very least, we must keep telling ourselves we're not God. A humbling implication of this admonition was pointed out by Aristotle many years ago. Human justice is not perfect. We will never completely attain the immutable ideal, but we must try. Thank you. Questions?